Morning.
Morning. So voidable transactions. So we're here to talk about voidable transactions, and Damien has dubbed us the Unofficial Assignees.
It's a good name.
Yeah. So we're going to start with Damien talking about a bit of the history, then we'll launch into what is the regime and some of the defences and tricks to avoid liquidators.
You can never avoid a liquidator. The regime actually has its history a long way back. Originally in 1571, Queen Elizabeth I of all people. And there was a real problem at the time with people who owed large amounts of money would just gift it often to the church. And then when the creditors came looking, there they were surrounded with all of their assets, but technically all these assets belonged to the church. So Queen Elizabeth I passed a law saying that any contract entered into for the sole purpose of avoiding creditors was discarded, could be set aside. And that law remained in force in New Zealand up until about 1952, when it was replaced by sections of the Property Law Act. So it's a really fascinating law and a lot of really interesting history. But perhaps the first, what we would consider to be insolvent transaction law, happened in 1868. And there was a minister of the Anglican Church, and he gifted all of his assets effectively to his housekeeper, Miss Walpole. I'm sure she was a lovely housekeeper, very efficient.
When I did that?
It's a mystery. It's a mystery. After the Reverend died, one of his creditors, Mr. Freeman, a carpenter, turned up and says, "Hey, when you were solvent, you gave away all of your assets and you became insolvent." And the court agreed with that, relying on this 1571 law, and all of the assets came back and was able to be used for his creditors. And a not dissimilar thing happened back in the late 90s in a very famous case in New Zealand called the Regal Casting case, where you had a gentleman called Mr. Lightbody. Mr. Lightbody owned half his house along with his good wife, and he then proceeded to gift his house under the regime as it was then at about $27,000 a year, until such time as there was no equity left. Now, Mr. Lightbody had a personal guarantee with one of his suppliers he had a company called Regal Castings, and he had a personal guarantee to one of his creditors. The company went into liquidation and Mr. Lightbody went into bankruptcy. The creditor who had the personal guarantee went back to the official assignee using the same argument, says, "Hey, you, Mr. Lightbody, dissipated your assets for the purpose of defeating the creditors," and the court agreed and hauled it back. So today, while we're talking about voidable transactions and company law, the history really is all tied in with personal bankruptcy. The law in New Zealand for a long time, so the way that Parliament and the courts were interpreting voidable transactions was all around this attitude that you had to be just before you could be generous. So you had to pay your creditors before you could dissipate your assets. Now in New Zealand for a long time there was a voidable transaction regime, and it was built around this very idea that if you had assets, you were running a company, it was insolvent, and then you proceeded to pay some creditors over others, then the creditors who received the benefit, they would be forced to disgorge some of their assets back to be split out on a what's called a pari passu, or equal step, or most people pro rata is the name that they would understand. And so the idea was Parliament didn't want a company director who had assets but not enough to pay all of his creditors. They didn't want that director to be the one who decided which creditors would get paid and which ones wouldn't. And obviously the ones they would choose to get paid would be those that they had a personal guarantee.
So in the construction space, I mean, that's the Bunnings, the placemakers, I mean, those are the common ones that we see getting paid.
Yeah, so those are the guys who have voidable transactions. So the company director, when he knows the company's going into trouble, will then proceed to pay out those who've got personal guarantees. So the regime is designed to haul that back. So Brent, you've been working in this space for quite a long time. What's your understanding now of exactly how the law and what the voidable transaction regime is?
Yeah, so I've had this really, really interesting experience where I exclusively acted for liquidators for a big chunk, and now more often than not I'm on the other side of these things, doing God's work. And so it's really interesting to see both sides of that coin. And in terms of the voidable transaction regime, what you need to prove, so liquidators, if they want to bring these cases, as you know, they need to prove that there was an insolvent transaction. So a transaction that occurred at a time when the company couldn't pay its debts, and that allowed a creditor to receive more than they would have in a liquidation.
Yep.
And liquidators can look back 2 years. So there's two periods, 2 years or 6 months, and the standard of proof is different for liquidators in those periods.
So when does that 2-year period start?
So it depends if it's a court-appointed liquidation or a shareholder-appointed. So if it's shareholder, they can look back from 2 years prior to the date of liquidation. If it's court-appointed, 2 years from the point that the creditor filed the statement of claim to put that company into liquidation.
So we'll come to what an insolvent transaction is, but what you're saying is if an insolvent transaction occurs earlier than 2 years prior to that liquidation date, then that can't be called back.
That's right.
Right. Okay.
So, and it has to be at a time that the company was unable to pay its debts. So there would have been debts outstanding that were legally due at the time that the company couldn't pay.
Right. And so just what are the sort of insolvent transactions that you're seeing liquidators pursuing at the moment?
Probably more than they should. So not your firm, of course, but I see a variety of firms. And so, I just see complete shakedown approaches, for $5,000, and we see transactions that really are not voidable, that where creditors have good defences, and so what we see is this is a bit of a we'll get to this later, but as a regime to fee generate for liquidators most of the time.
Well, I mean, we're jumping ahead surely. So let's just say focus a little bit on what actually is a avoidable transaction. So what are the criteria? So you've spoken about that the company must be insolvent when the transaction is made. You've also so talk a little bit more about the preference. I mean, how does that work? What's that? But also, we can talk a little about, because we've also got the situation with the Inland Revenue Department and staff being having a preferential being preferential creditors. Talk about that.
So to talk about preference first, what we see is, like I said before, so one creditor, two creditors, they get a preference over others. So you've got the suppliers who don't have PGs, they don't get paid. You've got the Bunnings or placemakers of the world with PGs, they get full payment because when the director liquidates his company, they want to be able to walk away clean.
So taking an example, you've got a company with, say, 100,000 worth of creditors and 10,000 worth of cash. The company director then pays that 10,000 in cash to, say, placemakers. So placemakers then get a $10,000 preference toward the other creditors. That's what you're talking about.
Yeah.
Right. Okay.
Yeah, or it could be a friend of the show. It could be family. Somebody that the director wants to look after over somebody else. It's not always necessarily the person of the PG. It could be his uncle or whoever. Anybody
who's exercising leverage.
Yeah.
Yeah. Okay. So, and how does that play out in a practical sense? So, you're now in a situation where you are defending company directors, or you are defending creditors from liquidators. So you talked about the shakedown, but more generally, what is the basis upon which liquidators are making demands?
So for the process is you'll always see a demand letter, and it's always the same one. So every firm has their template, as you do as well, and some firms have a two-page template, some firms have a 7-page, but they regurgitate it. And there's only ever three differences on every letter they send, and it's company liquidation, the recipient, and the amount. But when the recipient receives that notice, it's a very daunting notice to receive. It's got Companies Act attachments to it. And
so put yourself in the situation of a creditor. So I'm a creditor in a situation, I've been trading with a company, maybe I knew they were in trouble, maybe they weren't. But I've been trading with that company, maybe I stopped trading, maybe I'm continuing trading. How am I, what am I going to get from the liquidator?
yeah, so after that, you're going to get to a voidable transaction notice.
Which is what specifically?
So when a liquidator wants to set aside a transaction, they have to issue a notice, give you 20 working days to respond. They have to set out the details of the transactions.
And is that a notice just written by the liquidator, or is that something that they've gone to the court to get first?
No, it's written by the liquidator, filed at court,
Yeah.
but it's not a court proceeding.
But you actually get a bit of paper with the registrar's stamp on it.
That's right.
Because that's quite intimidating.
Yeah, it is. Yeah. And then if you don't respond to it, the transaction is automatically set aside.
So if they get one of those, they need to go and talk to a good insolvency lawyer.
Yeah, correct. Yeah, yeah. Because failure to do so is, you lose all arguments except for was there a transaction, and do you have a defence under section 296(3),
Right.
which we'll come to.
Right. So now's probably a good time. So let's talk a little bit now about section 296. So it's a two-step process, though, isn't it? So the first step is that you have an insolvent transaction. So you as a creditor, you have received more than perhaps you were entitled to from a liquidation. The mere fact, though, that the transaction is voidable, so you've received money at a time when the company was insolvent, and that has meant that you have been able to get paid disproportionate ahead of other creditors. So now, does that automatically you mean you have to pay the money back?
No. So creditors do have a defence.
Yeah.
So they have to prove three grounds, all three. Acted in good faith when they received the payment, that they had no suspicion of insolvency, nor would a reasonable person in their shoes, and that they gave value for the transaction or altered their position as a result. So practically, everyone usually acts in good faith. Practically, they give value because they've provided a good or service, and so you can quite easily tick those two boxes. Majority of the cases come down to suspicion of insolvency.
So just stay with that. So 296. So they needed to have acted in good faith, which is normally a given. They needed to have no knowledge of insolvency, and they needed to have provided value. So how many of those three do they need to tick?
All three.
They need to tick all three. Okay. So if I have received money as a creditor and and it was a voidable transaction, I don't have to pay that money back if I can show, one, that I acted in good faith, B, that I had no knowledge that the company was insolvent, or a reasonable person in my position wouldn't, and that I had actually provided goods and services. Does it matter when I provided those goods and services?
Yeah, so there can't be a voidable transaction if it's a cash on delivery situation. So, over the counter, here are the goods, here's the cash, then it can't be avoidable. It can only be avoided if it's a debtor-creditor relationship. Yeah.
So if I go up to a hardware store and I pay the hardware store, I sell something to the hardware store and they give me some money, so I supply them some hammers for them to sell, and they pay me straight away. That's a one-off kind of transaction. There's no debtor-creditor relationship there, so I can't get pinged for that.
No.
But if I had an ongoing trading relationship with that store, how would that work?
Yeah, so it depends on the specific case, but that puts you at risk. So as soon as you extend credit, you're at risk of receiving a preference over other creditors, and that's what brings you into the regime.
Right. So my understanding was that the way the voidable transaction works is that, okay, we have the starting point, and let's say it's 2 years for the sake of simplicity. So we have a starting point. At that point, you are receiving money from your customer, and you might be owed, say, $70,000. Between that point and the point that the company goes into liquidation, you sell them, you provide them with goods, and you get money. So you go from, say, $70,000 to $5,000. That change in position, that $65,000, that's what potentially can be clawed back. You may have done, in that period of time, you may have supplied them millions of dollars, and you may be paid millions of dollars. the only thing the court will look at is what was the debt at the start of the 2-year period and what was the debt at the end of liquidation. So it's that movement that is considered what's voidable.
And that's, I suppose, when we're looking at the way that liquidators approach their voidable transactions, so we're talking about a running account here, that's what they often, purposefully, in my view, overlook. So, I had one recently where $100,000 was demanded from a creditor for money received over a 2-year period. When the creditor saw that notice, they were quite concerned. When I actually look at the transactions of, supplier payment, and you look right through that 2-year period, the only amounts that were subject to any risk was this last $5,000, which was after that relationship had ended, and everything else was just on normal terms. And so, you have to be really careful about how you deal with these liquidator letters, because often they will put their best possible foot forward, and why not?
As they should.
Why not? Yeah. But
although maybe they shouldn't. I mean, if you are a liquidator, whether you are appointed by the courts or appointed by the shareholders, you are an officer of the court. So it's a real, maybe liquidators shouldn't. Maybe liquidators are sitting there, you say, putting their best foot forward, but perhaps they're being somewhat naughty, because the liquidator should not, this is an area of the law that the liquidator knows really well. The creditor may only deal with this once, so maybe the liquidator has an obligation
well, it depends,
to be
right?
a bit more.
So we're going to go slightly off topic, but under the current regime, there would be no obligation on the liquidator to do that. But if they are a liquidator who subscribes to the returns code, then they absolutely would have obligations to be very transparent.
My understanding is a code is more kind of advisory rather than something that they all stick to.
Like, going off topic, that's a rabbit hole. But yeah, I mean, it depends. If they're going to submit themselves to voluntary regulation, then they may have some.
Okay, so you're right. We are getting off topic. So we have a situation. So one of the things that for creditors to be aware of is that the only thing that is voidable is not all the money that they have paid a company in liquidation. It is only where effectively that money is solely for the purpose of reducing the debt.
Yeah,
right.
And like, I mean, so we're really clear. So the liquidator needs to prove that the company was unable to pay its debts at the time.
So, so let's talk about that for a second. So there's two different dates, a restricted and a specified. So maybe talk, what's the difference between the two?
Yeah, so in the 6 month period, there's a presumption that the company was unable to pay its debts. In 2 years, liquidator needs to prove it.
In the first 6 months leading up to the liquidation, it is the obligation of the creditor to prove that the company was insolvent.
Disprove it was insolvent, yeah.
Yep. So, but if we're going from 6 months to 24 months, in that 18-month period, it is the creditor who must prove, it's the liquidator who must prove that the company was insolvent. And one of the things that liquidators do to prove insolvency is we look for old creditors. And 9 times out of 10, the oldest creditors is the Inland Revenue Department, because companies getting into trouble almost never pay their taxes.
Yeah, yeah. And so let's talk about that. Let's talk about what, as a liquidator, you would look for.
Right. So the things we look for. Well, sometimes as a liquidator, it's quite difficult because we often only see one side of the ledger, so we don't always get the full set of accounts. So what we will see is we will see money, in particular if it's a court liquidation, all we see is money going out of the account to the creditor. And so we'll ask the creditor for a statement of account. If they don't provide the statement of account, then we will issue a voidable transaction for all of the money that they received. The burden of proof then flips onto the creditor. They need to demonstrate, if they want to claim those 296 defences, those running account defences, if they want to say, hey, we received $1 million in the last 6 months of the company's life, but we provided $950,000 worth of goods in the last 6 months, then the voidable transaction is only that $50,000. But sometimes creditors refuse to engage with liquidators for reasons that you will discuss shortly. But from our perspective, if they don't give us a statement of account, we will void all of the transactions.
But you can only seek to void the transactions that are in the bank account, right?
That's true.
And that's why we would often advise people, hey, don't give the liquidator your statement of account, because often in the lead up to that failing business, directors will pay money personally to the creditor, and those won't necessarily be on your radar, right?
Well, let's talk about that. So we have a situation where the company director pays the money to a creditor directly. So why would that be considered a voidable transaction? Because that money came from the director. How can the liquidator claim that to be a transaction that can be voided?
Yeah, so there's a whole bunch of cases that allow transactions from the director's account to be a transaction for the purposes of a voidable transaction. I think the earliest one was National Bank and Coyle, and I mean, effectively, it's treated as this is a company debt. The director has paid it on behalf, and had the company continued to trade, that would have been an entry on their current account, and it would have put them in credit with the company.
So the company director pays $50,000 on the company's behalf to a creditor. The company then owes the company director that $50,000.
That's right.
So the courts will say, hey, that $50,000 is a transaction that the liquidator can claw back, even though the money didn't come from the company's account.
One of those form and substance type transactions. So the form of the transaction was between the director and the creditor, but the substance is between the company and the creditor. So those transactions can still be subject to risk.
Right. So before we come to talk about the tactics, maybe we'll talk about the Il Forno case, one that we were both involved in. That was a spectacular
disappointment. But now I'm on the side of the fence. It's brilliant.
Well, talk about what happened in that case, because that was a fantastic case.
Yeah, so she had this classic situation where
you lost.
No, Alden.
Oh, okay.
sorry, mate. Sorry, Alden.
Go on.
So,
he's now working for Norling Law.
That's correct. Oh, soon. And so you had this fantastic situation, classic, where you had a creditor owed money, issued all the demands, statutory demand, liquidation proceedings, put a whole bunch of pressure on the debtor company to pay.
And so, just on a thought for a second, so what that means is that the liquidator can say, hey, you issued a statutory demand, you issued liquidation proceedings. That is clear evidence that you had suspicion of insolvency, and may even mean that you weren't acting in good faith. So from that perspective, remember under 296, if a liquidator can ping you for any of those three defences, acting in good faith, knowledge of insolvency and giving value, if they can just ping you on one, knowledge of insolvency, then that $50,000 is voidable. So how did the creditor in that situation avoid being pinged voidable?
It was worse, because in that case there was pretty good evidence that they did know the company was insolvent. And so if that was to be brought into the voidable transaction regime, it would be quite open and close. So what they did,
the creditor.
What the creditor did, and I think possibly unintentionally, but successfully avoided the voidable transaction regime, was to enter into a deed of settlement with the company director. So they said, you're going to pay us, the shareholder actually it was. So they said, you're going to pay us this money, and there was to be some arrangement. So they wanted the arrangement to be directly with the shareholder, so they had some leverage, and there were deeper pockets over that side. But the effect of constructing that in a deed is that the actual legal obligation to pay shifted to the shareholder, not the company. And in that case, they actually agreed not to claim against the company for the amounts that they advanced. So,
well, the other issue was that part of that deed was for the extinguishment of the shareholder's personal liability. Because in that situation, the shareholder had a personal liability to the creditor, and the deed said that if you pay us this money, which wasn't the full amount of the debt, if you pay us this money, we are. So what he was really buying was an extinguishment of his personal liability, and because of that, then it wasn't a reduction of the company's. The court found that the creditor in that situation didn't receive a preference.
Yeah, that's right. And so there was no transaction that could be set aside.
Deeply disappointing.
Yeah, well, it's a good track. It's a good track.
Alright, so maybe we just talk a little bit more about the tactics. So one of the things that what do we do as a liquidator when we're looking for things? So the first thing we look for is all of the information. So we get a liquidation. Sometimes we have the books and records, sometimes we don't. Sometimes we don't have all of the books and records. Often all we have is the bank statements. So we go through the bank statements, and if we see money going from the company to somebody else, particularly if it's like a set amount, $10,000 a month for 6 months, that to us looks like the reduction of a debt rather than the payment for goods and services. So that's a red flag for us. So we look for that. We also troll through the company's emails. So we're looking for situations where a creditor says, look, I know you're insolvent, you haven't paid me, I'm hearing all of these rumours, if you don't pay me, I'm going to begin liquidation proceedings, if you don't pay me, I'm going to put you on stop credit.
So how do you get those emails?
Well, quite often we actually have the email server, which is really easy. But sometimes if it's a court liquidation or it's a messy shareholder situation, we often don't. So sometimes we need to get those emails from the creditors that we're going after. And sometimes they give it to us.
And what happens if they say no?
Well, if they say no, so we have two ways of collecting information. Section 261 of the Companies Act, and that allows us to get books and records that belong to the company. And we would make the argument that those emails are records of the company. The creditors themselves would argue no, they are documents that belong to the creditor, not the liquidator. Well, in that situation, if they won't give us the documents, we can always go to the courts under Section 266. And under 266, we can get the court to force them to give us those emails. So 266 is much wider.
So I know you do that. You mean
yes.
You ask for documents, if they're not provided, you go to court, you get orders, you get them, and usually you get a cost order.
Yes.
But that's not that common, is it?
No, it's not, and the dollar value needs to be really, really high. A really fascinating case, which is run through the courts, reasonably high profile, is one between Sir Bob Jones and PKF and Stephen Lawrence. And in that situation there, it's a fascinating case, $750,000 involved. There, the liquidators, the whole thing was a mess because a statutory demand was issued by the creditor against it was a blue chip entity that went down. So this blue chip entity had been leasing property off a Robert Jones company. They had left the building but continued to pay, and the money actually came from different entities in the blue chip group, not the company in liquidation. And Robert Jones Holdings was not going to provide the liquidators with anything. I think they were possibly aware of what had happened. So in that situation, the liquidators had to go to incredible lengths. They had to fly to Australia, get accredited in Australia, collect the books and records, bring it back to New Zealand, and then pursue that against Robert Jones. But in that situation, they had evidence of insolvency because Robert Jones had been pursuing hard the entity that had to pay the money. So it went on for several years. There was liquidation applications, stat demands, all the rest of it. But then out the other side, there was the money that came in didn't come from the money in liquidation. You were talking before about the shareholders paying the money in. Here you had two other blue chip entities paying the money to Bob Jones, or the Robert Jones Holdings, sorry. So in that situation, the court finally ruled that that $750,000 of rent that was paid to Robert Jones Holdings after this blue chip company had left the building, that $750,000 was voidable. And what was even more interesting in that case is Robert Jones Holdings Limited ran the argument, pure sophistry, that the sole purpose at that point of the $750,000 was to pay liquidators' fees. And fortunately, the courts ruled that wasn't the case. But in fairness to Stephen Lawrence and PKF, the only reason why the fees would have been so high in that situation is that Robert Jones Holdings litigated this so hard for so many years. So that was a really interesting case that I think it's gone to the Court of Appeal. I think it's still potentially going to the Supreme Court.
It's not a. I don't think his argument is a defence, but he's not wrong. I mean,
who's not wrong?
Sir Bob Jones.
Oh, right.
So
Yes.
I mean, we see this. Of course, not at Waterstone, but we see this quite frequently in the industry. So the voidable transaction regime is designed to put all the creditors in equal standing and to share equally in the assets. But what actually happens is this becomes a fee generation exercise for liquidators, and creditors ultimately get none of that. That's a common theme that we see. I would love to see that succeed as a defence, but it's just not.
But nor should it, because if that could succeed as a defence, then all the creditor would need to do in that situation was play obstruction, and that's exactly what Robert Jones Holdings did. They litigated this every last cent. So had Robert Jones Holdings done a deal right at the start, then there may well have been a distribution to the other unsecured creditors of that blue chip entity. But there certainly won't now, because I imagine all of the money is going to go to lawyers or liquidators, although we don't know that for a fact. But that's a really interesting, from a practical perspective. If you receive a voidable transaction notice, in your experience, what's the best way to deal with that? Let's say you've got a client, they received the money, it was an insolvent transaction, and none of their 2-9 defences work. What's the best tactical approach then to deal with a liquidator?
So there's always uncertainty in litigation. So even if there's a good voidable transaction and there's no defence, there's always ways to muddy the waters. And so in that situation, we would muddy the waters, and we would formulate the best argument that we have. We'll put that forward together with a very early settlement offer, because.
And what sort of percentage are you saying that liquidators will accept?
It's varied. It's varied based on which firm you're dealing with, and it's varied depending on the actual value of the transaction. But what I can say is $5,000 seems to be a very common theme.
You mean a liquidator will sell out a voidable transaction position for a mere $5,000?
Yeah.
That's exceptionally disappointing.
Yeah. Often I'm just calling bluffs. So quite frequently we're just saying, look, we have a defence. This is a $20,000 claim or a $30,000 claim. Your legal cost to take this to the High Court is going to be, not too far south of that.
And do you see liquidators out there have much of an appetite to litigate this stuff?
No. So frequently I've just said, look, we're paying nothing. This is a low value claim. High Court will be disappointed to see you pursue this. If you want to proceed, we have instructions to accept service, and that works a lot. But there has to be some merit to a defence, because you don't want to risk calling the bluff and it's actually not a bluff.
So let's look again. So you have a situation where you are a creditor of a company that you know is insolvent. Is there any disincentive for that creditor not to do everything they can to get paid?
No, look, cash is king.
Yeah.
And so my advice, 10 out of 10 times in a situation where there's some cash available to get paid, is take the cash. Now, if you're involved early enough to structure it so it's not a transaction of the company, so you get shareholders to do a deed, then great. If not, take the cash, take the risk, because you're better off to have the cash and risk a voidable transaction demand.
Yeah, I would agree with that, because you have a look at a situation. There's no punitive element to the insolvent transaction regime. So if you receive money out of a company in liquidation, then first, for that to be clawed back, first the company must go into liquidation within 2 years. Right? So there's a good chance the company will survive. 2, you need to have a liquidator who's actually prepared to litigate this stuff. And the majority of liquidators don't even know where the High Court is, much less have an ability to go and pursue them. And then the third thing, you work on the assumption that the liquidator is not going to accept cents in the dollar in order to make this thing go away. So the reality for most creditors is that they shouldn't worry about this stuff. They should just go out there and do whatever it is that they can to get paid. And if they get caught in an insolvent transaction regime, head to Norling Law.
Yeah, well, I mean, I've seen cases where gifting was done to a related party of $1 million, and this was under the Insolvency Act, but same principles.
So by insolvency, to be clear, you're talking about a personal bankruptcy.
I'm talking about bankruptcy, but
Yeah.
it was a voidable gift,
Yeah.
and they can go back 5 years under the Insolvency Act.
Yeah.
And the guy that cut a deal where he paid $200,000
to the official assignee.
Yeah. So he was disappointed with he had to pay $200,000.
But he got $1 million.
Well, he got $800,000, and that asset
position
went up in value over those years as well. So, if you could go back and change anything, you'd do nothing different. You would do the gift, and then you'd risk paying the $200,000 because the appetite to litigate at the official assignees office is even lower than private practice liquidators.
Which is incredible. They have the endless resource of the state.
It's not that endless, apparently.
Ask the teachers. All right. So I think we've covered off as much as we can today. So that was the unofficial assignees on voidable transactions. We'll be back with more stuff in the future.